actually, zoning board of appeals to order. Heidi, could you call the roll, please?
Ellen Cornell,
Absent with cause.
Thomas Callahan,
Present.
Keith Kyle,
Here.
Christopher Almond,
Here.
Joseph Pagliett,
Here.
Anthony Bernetti,
Here.
James Manning.
Here.
Mr. Chairman, you have 6 members present.
Thank you. Mr. Callahan will not be voting on this, he's just sitting in, so it's 5 members. Where do we begin?
I mean, it's entirely up to you. I want to go over a couple of procedural
Yes.
issues if we can.
I'd love to.
All right. First thing was number 5 on my list, but number 1 would be you're going to have to obviously consider these separately, review them separately, separate votes for every one of these applications. So even though they were argued kind of jointly on a lot of different occasions, Mr. Chairman, I'll ask if you call, we'll do one at a time.
Yes.
And we'll decide one at a time. Just, again, I'll kind of review the, the standard of proof, etc. Again, stop me if you have any questions. I had read this to you before. Can you hear me with the, I'll try to speak up. When reviewing a determination of zoning enforcement, officer of the board may reverse or affirm wholly or in partly and modify the order, requirement, decision, or determination appealed from, and make any orders, requirements, decisions, or determinations that ought to be made, and to that end has the same powers of the officer from whom the appeal was taken. Obviously, we've heard this kind of from scratch. Rule 5I of our rules allows for the presentation of new evidence for which you've heard. The parties have agreed that the standard of review is substantial evidence, which means more than a scintilla but less than a preponderance. In the past, I had given you a different standard. That's the standard that, frankly, I had been using for 30 years, and no one has, many law firms have been before me here and in Cranston, and no one's ever questioned my preponderance of the evidence. However, the parties agreed that substantial evidence would be the standard of proof. Again, everything voted separately. We had some, you guys have all the briefs. Not gonna review all the briefs. My advice would be to make a decision on these tonight if you possibly can. Right now, there was an issue of subpoena. If you wanted to, my advice would be to try to decide it on the record. Also, I want to point out that should you decide to consider the second amended complaint in your decision, that META Plat NR Lot 12049 Joy Lane was not part of the second amended complaint, so please keep that in mind. With that, if you have any questions, both sides have argued regarding the definition of unrelated, whether it's clear or unambiguous. If something's not defined in our ordinance, it's my opinion also that you can certainly use the plain meaning of that ordinance, of that wording. That wording comes from our State Enabling Act, which has been around since I've been a lawyer in 1992. It is in many different towns. It's obviously in Narragansett. There's been a also major change in our zoning planning laws, which you guys will get a tutorial in a couple of months. That definition remained the same in the new law. That has not changed either. So the legislature not only kept that the way it is, but for your consideration, we have to deal with the law as it stands. I don't know if you want to hear from the parties at all on any of the issues which they briefed. I'll leave that up to you, Mr. Chairman. So that's kind of standard of review, decide each one individually. The kind of the base law, you can certainly consider in my opinion, consider the additional evidence, and it would be my opinion that you should decide this, if all possible, decide this tonight.
All in agreement there.
Mr. Chair, I just had 2 housekeeping issues to be heard on when you're ready.
I have one question before we start
Yes.
with Steve. So, since I think at the start of this year or whatever, we kind of have an unwritten policy that when we set forth the statement of facts or the findings of fact, now that we more than just reference the record as the detail. So, with respect to these, given that there are 5 matters before us, I'd still like to be able to do that in the statement of facts. I think we can break out the decisions separately, but the facts are the facts, and it was the same facts that were presented basically with respect to each.
I believe
element.
the presentation was the same regarding, there was a presentation of the rental registration, presentation of the number of occupants in the property. I don't know if the number of occupants is disputed. There was the individual testimony on each of the matters. Certainly you can reference those if you want to pull out any additional facts or highlight any additional facts, you certainly can do that also.
Well, it's not my intention to prolong this any longer than we have to. I have no intention of issuing any subpoenas in this case. So I don't see where we cannot move forward with decisions on each of these this evening. So, well, you have.
Yeah, just quickly, just for the record, obviously you heard, I'm not going to belabor, we objected about the second amended complaint. In my brief, I did note the filing of the third amended complaint that has been filed and is pending before the court, and that, once filed, would supersede the second amended complaint. I have the third amended to the extent you want it, but those paragraphs have changed that the town is relying upon. So I do have that if you want me to put it in the record. I do still object to the use of any of it.
Yes, I understand.
But I just want to make that clear for the record that obviously the town has the third amended complaint, but if...
So your third amended complaint, the court has not acted on that yet?
Correct, so it was filed the 20th. It will be, when objections due the end of this week or Monday.
Okay.
And then leaves freely granted, and there's no discovery's been conducted in this for the lawyers on the board. I'm sure you know what that means too, so I don't envision that this will be not granted, but so. And then the second thing we had, which is also referenced in the memo, is we do have affidavits to put to bed the subpoena issue, just so we weren't dragging this out another meeting. And I don't feel the need to introduce those to most of them, except for the Rinaldi action, where there was some hearsay testimony from Mr. Pimentel about what Mr. Green said. So I do feel the need to introduce an affidavit from my client which disputes the fact that there was any discussion with anybody with respect to whether they were unrelated or not. I have an affidavit from both my client, who was at the site inspection, and Mr. Robenheimer, who was at the site inspection. and I can read the relevant paragraphs in the record. They're not voluminous affidavits, but Mr. Rinaldi talks about being at the inspection. It says, paragraph 9 says, David Green visited the property on October 4th, 2022 and could not access the property because no one answered the door. In fact, Jamie LeBreton, the town's rental clerk, forwarded an email dated October 4th, 2022 at 9:54 to me saying Green visited the property but could not gain access to the lease. And then it also says Green did not discuss the relationship of any of the tenants during his October 4th visit to the property. And then Mr. Robenheimer, who Mr. Green said he spoke with, also has an affidavit refuting that as well. To the extent that's actual evidence in the record, we feel the need to put it on the record that that is not consistent testimony.
Steve, there's no problem accepting that.
No, you can accept it, and obviously, since they're not here, you can, weigh the weight of the
Right.
evidence. But I would, if you could, Joe, if you could give a copy to
Yeah.
Heidi or.
To whoever wants it.
Where are we marking this, Steve?
We are on.
I don't have my notes with me, my apologies.
I was thinking of that 2 seconds ago.
That's probably
After
out.
the list,
I think it's F.
it's in the file?
It's in
And G.
Oh, yeah, there you go.
You just go right to M and leave a little space.
And we know there's no duplicates.
I think it's G's next.
Yeah.
Do you have an extra, do you have an extra copy of it?
I don't know how many they
Seems to be
Andrew,
Yes, ma'am.
Thank you.
do you have just Robenheimer?
I am just Robenheimer.
Is it not?
Okay. Sorry.
Make sure the clerk has one.
I'll mark this one. 26.
And, Mr. Chairman, if you do want the third amended complaint in the record.
I'll accept that.
Okay. Yes, ma'am. Can you just hand this to Well, yeah.
Sorry, the third amendment complaint is massive, so we only have 3 copies.
Thank you. Yeah, you can mark this also.
Yeah, I'm gonna do, I think this one's gonna be G.
Sure.
The last one I have entered in.
These ones are over there.
Well, that's what I'm gonna say, it's not that we agreed to it, it's not that it doesn't
I feel like when you're in elementary school and you get told
No, we
you're
don't want
passing everything out.
Mr. Chairman, I just want to make a couple of points, just a couple of points, in response to Mr. Marcel's opening statements.
Yes.
So, just a couple, of again, not to belabor anything, but with regard to this whole standard of substantial evidence versus preponderance, I don't think that we insisted that it's substantial evidence. I think what we said was it doesn't matter because there's no evidence. So I don't think that we insisted on substantial evidence. And also with regard to the fact that the definition, well, Ms. Marcello kind of characterized that there's a definition in state law of unrelated. That's not the case. It's not defined in state law either. So unrelated is not defined, and I think my sister Joelle here did a good job of identifying lots of different provisions of the definition of unrelated in Merriam's dictionary that Mr. Zangari had only put, the family type relationship. That's what I want to say. Thank you.
The complaint? Yeah. That.
Well, gentlemen,
I would make a motion to adopt the following findings of fact, which would be pertinent to each of the 5 appeals, in as much as I'll refer in a minute, most of the evidence, if not all of the evidence that was adduced at the hearing was applicable in various ways to each of the appellants. So, as I see it before the board are 5 appeals of notice of violations issued by the town of Narragansett building official, for alleged violations of the Code of Ordinances, Appendix A, Section 2, the so-called 4 unrelated ordinance. Appeals were asserted by Michael and Lee Nita, 9 Exeter LLC, ETRI Seconic Boulevard Investments LLC, John and Sandra Rinaldi, and Eastside LLC. This board held hearings on April 25th, 2023, and again on May 18th, 2023. At these hearings, the town called as witnesses the zoning official Wayne Pimentel and David Green to testify in support of the alleged violations by the 5 appellants as noted in the notice of violation. Their testimony is noted in full in the record of the proceeding, which has been transcribed and is incorporated into this matter. In addition to witness testimony, the town solicitor introduced various exhibits, all of which were marked as full exhibits and are also incorporated within this statement of facts. Of particular note, the town introduced into evidence the so-called second amended complaint filed by appellants BTRI, 9 Exeter, John and Sandra Rinaldi, and Eastside LLC in the Washington County Superior Court, Civil Action Number WC 2022-0491. That matter was removed by the town to the United States Federal District Court for the District of Rhode Island, and it's now case number 1-23-CB-0087, and Mr. and Mrs. Mita were not party to that proceeding. And that would include my findings of fact.
I'll second.
Motion has been made and properly seconded by Mr. Holman to enter the findings of fact into the record.
Okay, Mr. Brunetti seconded.
Chris got it.
Chris got it.
Chris beat it.
Is there any discussion on this motion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0.
All right, so based upon that, now we gotta call each one individually, incorporate that motion into whatever motion.
Which one would you like to start with? Keith?
I'll just start with Mita. I think it's the easiest one to deal with.
Oh, Mr. Chair, just for the, I'm sorry, can you just Mita, plat,
Okay, I'm
just
sorry.
like you normally do? I'm sorry.
In regards to,
I don't know if I have that in front of me. I have the,
uh,
Do you have the document?
never mind, stenographer has it, beautiful.
all right, in regards to Mita, 49 Joy Lane, plat N-R, lot 120. What is the board's pleasure?
Chairman, members of the board, with respect to the notice of violation relating to Michael and Lee Mita, I would move to grant or sustain their appeal because there was no evidence introduced at the hearing in reference to their violation notice, which would allow a finding that there was substantial evidence, which, as our solicitor has described, is legally defined as being more than a scintilla of evidence but less than a preponderance, that they violated Appendix A, Section 2. Simply put, there was insufficient testimony adduced from which I believe this board can reasonably conclude that the occupants of their rented home, although concededly more than 4, were unrelated, as that phrase is commonly understood, meaning not related by blood or marriage. The only relevant evidence introduced was that more than 4 persons occupied their home at the time the inspector visited.
I'll second that motion.
A motion has been made and properly seconded to vote in favor of the appellant. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0.
Now, Steve,
Yeah.
with respect to the remaining ones, I can cite them all, but it's gonna be the same decision.
Correct, but we have,
I
because
mean, you want me to do read this 4 times?
I would prefer if you did.
Okay.
I apologize.
I have no problem.
You know,
Be here for a little while.
I know they're represented, well, one's represented by different counsel,
Got it.
and they may have different, they're separate appeals.
Yes,
All right.
okay.
And so I prefer it be done separately.
So in regards to East Side LLC, 11 Walcott Avenue, Plat S, Lot 140, what is the board's pleasure?
Chairman and members of the board, with respect to the notice of violation relating to, I'm sorry, which one are we doing?
East Side.
East Side LLC, I would move to deny their appeal, but for one crucial piece of evidence that was not present in the META appeal. This appellant, in the court pleading referenced in the findings of fact, admitted the following. And this document was introduced into evidence by our solicitor. In the second amended complaint at page 14, which before we get into the specific allegations states, it's stated in the complaint the plaintiff's specific factual background, which belies the notion that these were alternative pleadings. With respect to East Side NOV at paragraph 92 of the amended complaint, they state, prior to the town's adoption of the 4 unrelated ordinance, East Side and its predecessors in interest used and continue to use 11 Walcott Avenue to rent to more than 4 unrelated individuals. Without this admission, their appeal would also have to be granted or sustained like META's, because there would otherwise be little to no evidence that the board could rely upon. However, this admission provides the missing evidentiary link not present in META. And even if these admissions are made in another judicial proceeding, are not conclusive as judicial admissions in this appeal, they are nevertheless some probative factual evidence that this board can rely upon in each appeal to support the issuance of the notice of violation, subject to contradiction by any other evidence offered by the appellants. And I'll note in the record that the appellants, having had the second amended complaint admitted into evidence, did not offer any evidence to contradict the admission just referred to. That's with respect to East Side LLC.
I will second that motion.
A motion has been made and properly seconded to uphold the building official as far as East Side LLC goes. Is there any discussion on this motion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0. All right, in regards to 9 Exeter LLC, it's the board's pleasure.
Chairman, members of the board, with respect to the notice of violation relating to 9 Exeter LLC, I would move to deny their appeal. As I stated in the earlier one, but for one crucial piece of evidence which was not present in the META appeal, these appellants in the court pleading referenced in the findings of fact admitted the following at paragraph 81 of the second amended complaint. Prior to the town's adoption of the 4 unrelated ordinance, 9 Exeter and its predecessors in interest use and continue to use 9 Exeter Boulevard to rent to more than 4 unrelated individuals. without this admission, their appeal would also have to be granted or sustained like Mita's, but because there is no evidence, because there would be no evidence that the board could reasonably rely upon. However, in this case, the referenced admissions provide the missing evidentiary link not present in Mita, and even if these admissions are made in another judicial proceeding are not conclusive as judicial admissions in this appeal, they are nevertheless probative factual evidence that in this appeal support the issuance of the notice of violation subject to contradiction by other evidence. And I would note again with respect to this appellant that even though the second amended complaint was introduced as evidence, the appellants did not offer or adduce any evidence to contradict the admission found in the second amended complaint.
I'd second that motion.
A motion has been made and properly seconded to uphold the building official in regards to 9 Exeter LLC. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0. Okay, next would be BTRI Secana Boulevard Investments.
Chairman, members of the board, with respect to the notice of violation relating to BTRI Secana Boulevard Investments LLC, I would move to deny their appeal, but for one crucial piece of evidence not present in the Mita appeal, these appellants in the court pleading referenced in the findings of fact admitted the following at paragraph 85 of the second amended complaint. Prior to the town's adoption of the 4 unrelated ordinance, BTRI and its predecessors in interest used and continue to use 36 Secana Boulevard to rent to more than 4 unrelated individuals. Without this admission, their appeal would also have to be granted or sustained like the Mitas, because there would otherwise be limited evidence that the board could rely upon to sustain the appeal. In reaching the conclusion that the referenced admissions provide the missing evidentiary link not present in Mita, even if these admissions made in another judicial proceeding are not conclusive as judicial admissions in this appeal, they are nonetheless probative factual evidence that in this appeal support the issuance of the notice of violation subject to contradiction by other evidence. I would also note with respect to this appellant that they were aware that the second amended complaint was introduced as evidence and did not produce any evidence at the hearing to contradict the admission just referred to.
I'll second that motion.
A motion has been made and properly seconded to uphold the building official on BTRI Secana Boulevard Investments. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed? That motion carries 5-0. And finally, on Rinaldi.
Chairman, members of the board, with respect to the notice of violation relating to John and Sandra Rinaldi, I would move to deny their respective appeals. But for one crucial piece of evidence not present in the Mita appeal, these appellants in the court pleading referenced in the findings of fact admitted the following at paragraph 89 of the second amended complaint. Prior to the town's adoption of the 4 unrelated ordinance, I think this is a typo, but it says East Side. Should say it's under the Rinaldi NOV, and its predecessors in interest used and continue to use 45 Sylvan Road to rent to more than 4 unrelated individuals. Without this admission, their appeal would also have to be granted or sustained like the Mitas, because there would be otherwise little or no evidence that the board could reasonably rely on to find a violation. In reaching the conclusion that the referenced admissions provide the missing evidentiary link not present in Mita, even if these admissions made in another judicial proceeding are not conclusive as judicial admissions in this appeal. They are nonetheless probative factual evidence that in this appeal support the issuance of a notice of a violation subject to contradiction by other evidence. I would note here as well that with respect to Rinaldi, the second amended complaint was introduced into evidence as a full exhibit without any contradictory evidence admitted.
Second on motion.
Okay, a motion has been made and properly seconded in regards to Rinaldi to uphold the building official in this matter. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 5-0. I believe our work is done here this evening.
That's it. Motion to adjourn.
Chair will entertain a motion to adjourn.
So moved. Second.
All those in favor?
Aye.
Opposed? That motion carries 6-0.